Hello, my name is Babak Abbassadeh, President and CEO of Toronto Centre. Welcome to Climate Change and Considerations for Regulators and Supervisors, which is the latest webinar of Toronto Centre on the topic. Climate change and financial stability are two important public policy preoccupations today. Getting both right is critical for ensuring sustainable economic growth and poverty reduction. Through this webinar, you will be exposed to a range of issues, including, but not limited to, role of litigation in reducing gaps with respect to the climate change policy, legislative and other considerations, and the unique challenges in addressing systemic risk as it relates to climate risk. I would like to thank Ed Waitzer, a longtime friend of Toronto Centre and expert on the topic, as well as Ilana Singer, who's the chair of Toronto Centre's Securities Advisory Board. As some of you may know, Toronto Centre has also organized 3 international panels on this topic at the IMF and World Bank events, and we also have a number of publications. I encourage you to visit our website and take advantage of all of them. And finally, I would like to thank Demet Canakce, a program director of Toronto Centre, who's worked very hard on a number of issues related to climate change and related activities. Thank you, and I hope you enjoy this webcast.
Ed, it is so wonderful to have you here to discuss this important topic, one that is crucial to the capital markets and regulators and supervisors worldwide. Thank you for taking the time to participate in this Toronto Centre webinar.
Well, thank you, and thanks to the Centre for focusing on challenging issues of dealing with systemic risks, which is something that regulators are going to be facing increasingly in the future.
Can you explain what you mean by systemic risk?
Sure. Why don't I talk about it from the perspective of financial markets, because this is the Toronto Centre. And you know, if you think about how investment theory has evolved over time, in my lifetime, investment regulation was basically quantitative, that, pension funds and other financial institutions could only invest in what were called legal for life securities, bonds. They couldn't invest in equities because they were viewed as too high risk. We then, with the advent of the efficient market hypothesis, capital market theory, the notion was diversification allows you to manage risk. So if you're invested in a widely diversified portfolio, you're going to do better than if you stick to highly rated bonds. What we found over the last decade and more, certainly with the financial crisis in 2008, is that there are certain risks that are not idiosyncratic. They're not unique to a particular company or even a particular sector, and therefore they are non-diversifiable. And that's what I think of as systemic risk. So climate is one example. You can't diversify climate risk out of a portfolio. Income inequality would be another example. You can't diversify the political consequences of income inequality out of a portfolio, either sectorally or geographically. Retirement income security would be another example. They're non-diversifiable risks when we think of it from a financial markets perspective.
Ed, why don't we start off with your view on the role of litigation in reducing gaps, policy, regulatory, supervisory, or otherwise, with respect to climate change?
So climate risk is sort of a poster child, if you will, for systemic risks. We've had others in the past. Tobacco would be one. What we're seeing in the last several years is a proliferation of litigation around this issue around the world. And I think part of the reason is political dysfunction. It is just increasingly difficult for democratic political institutions to address systemic risks, in part, ironically, because politicians have the shortest term horizon of any major institutional leaders. Corporate leaders are often accused of short-termism, but politicians increasingly focus on daily polling results. And when you're thinking that way, the tendency is to punt systemic issues down the road. And it's the same whether it's climate or retirement income security or education or healthcare policy. All of the big systemic issues are becoming increasingly intractable. So that's one reason for more litigation, I think. The courts kind of fill the gap by default. The other reason is what I label the inherent conservatism of legal advice. Lawyers focus on backwards looking because the common law, they're looking at cases, and they tend to focus on telling their clients what the law is. Think of the analogy to hockey, where Wayne Gretzky talks about what makes him a great hockey player, which is focusing on where the puck is going to be. What we know is that the law is increasingly incredibly dynamic. So we see social norms, we see concepts like reasonable expectations, fiduciary obligations, informing the courts, who are prepared to radically alter the law, partly in the face of political dysfunction, regulatory inaction. So those are two reasons why I think courts have become very active in this area.
Thank you, Ed. That will be incredibly instructive for a number of the regulators and supervisors listening to this and watching this webinar. Now, building on that, what are some of the public remedies being used or that could be used to hold governments accountable for failing to protect the environment?
Yeah, the three major remedies that have been invoked, and this is all within the last 5 years. So, and the volume of cases, there are now probably 1,000 cases outstanding around the world. But the three buckets that I think of are the public trust doctrine, which basically has the courts articulating that certain resources that they deem essential for human well-being are in effect held in trust for the benefit of everyone. And that imposes obligations on governments to sort of protect those resources. The second legal doctrine that's being invoked is something called public nuisance, which again is that any activity that unreasonably interferes with the public's interest in questions of health, safety, morality, comfort, or convenience are issues where governments can be held to account in court and where governments are empowered to enforce obligations of others. And then the third bucket, curiously, is human rights. In Canada, we have the Charter, but in most kind of mature democracies, there is some instrument that protects human rights. And part of that is protecting against unreasonable risks or impacts on human health and well-being. So the scope of human rights over time is expanding, not shrinking. And those are the three doctrines that are most often, or have most often been invoked to impose obligations on governments through the court system.
So Ed, we've spoken about governments and their role in this area. What are some of the challenges and opportunities that you see for supervisors and regulators in this area?
Challenges are the same as for governments, right? Supervisors are, in theory, independent, but in practice, often subject to a high degree of political interference, directly or indirectly. Supervisors, any regulator likes to maintain the appearance of getting things done, and these issues are they're tougher, right? They're more complex, they're longer term, they extend well beyond the span of any supervisor or someone working within a supervisory agency. They're frustrating because the tendency is to say, well, how can we solve the problem? Because the problem is a global problem. Collective action, as you know, amongst regulators is challenging. So having said that, when regulators take a leadership role, the person who comes to mind, for example, is Mark Carney, who's the governor of the Bank of England, was the governor of the Bank of Canada, has had a huge impact as a thought leader, but also as a stimulator of work done by the Financial Stability Board, the Task Force on Climate-Related Financial Disclosure, both in motivating legislators, but also motivating the private sector to take responsibility.
Thank you, Ed. That will be very helpful for the regulators and supervisors that the Toronto Centre educates and trains, and particularly your comments about how regulators and supervisors can play an important role in this area. Now, you've written about the Paris Agreement becoming a recent focal point of legal claims. Can you explain to our audience what the Paris Agreement is and how it is being used to advance legal claims?
So the Paris Accord is a pact. I wouldn't call it a contract, but a pact within the United Nations framework law on climate change that has been entered into by, I think, 197 countries. The focus is on reducing greenhouse gas emissions and adapting to the impacts of climate change and providing financial assistance to developing countries which are affected by changing climate. The pact itself isn't binding, so it's not enforceable, or at least to date I haven't seen any claims seeking to enforce the fact that various countries, including the United States or Canada, have entered into it and are not complying with it. But it certainly informs social norms and therefore informs the court's view of reasonable expectations. And the same is true over the years. Think about the OECD statement on corporate social responsibility, which has found its way into dozens of court judgments with respect to the duties of directors, with respect to limited liability. The pact, I think, will similarly inform judicial intervention. The wonderful thing about reasonable expectations, which is this guiding sort of force for the courts, is that by definition, it isn't static. That is, reasonable expectations generate expectations. So, and our Supreme Court articulated this concept very succinctly in the BCE case, but other courts have done the same thing.
Ed, you referred to the Supreme Court of Canada decision in the 2008 BCE Inc. case, where it stated that the doctrine of reasonable expectations looks beyond legality to what is fair given all of the interests at play to address conduct that is wrongful, even if it is not actually unlawful. Can you discuss the importance of rulemaking around climate change that is based on reasonableness and this concept of reasonableness that you referred to earlier, and that can deter corporate actors from making decisions to merely maximize short-term profits?
So let's talk about judicial intervention and then rulemaking, because quite frankly, I don't see BCE informing a lot of rulemaking right now, and I'm not sure that it should. But BCE certainly said that directors have a responsibility to mediate the interests of all the stakeholders within a corporation. So BCE rejected the notion that shareholders have primacy in terms of the corporate hierarchy, and basically said as long as the directors can demonstrate that they've considered all the interests, acting in an informed way and without conflicts, courts shouldn't second guess their business judgment. BCE isn't new. The case that I love, which ironically is a U.S. case, and the U.S. has always been very shareholder-centric, is a case called the T.J. Hooper, which was a case decided by a very famous New York judge, Justice Learned Hand, in 1942. T.J. Hooper was a tugboat operator who sent a tugboat out into what turned out to be a storm without a shortwave radio on the tugboat. And at the time, shortwave radios were not mandated by any regulatory or licensing requirement. And Learned Hand said, I know they're not mandated, but it was irresponsible at that point in time, having regard for norms, to send a tugboat out, and the tugboat sank, and there were fatalities. It was irresponsible to send a tugboat out. Had the tugboat had shortwave radio, they would have known to get out of the storm. And Learned Hand said, I don't really care what the law is. So in a sense, it's a different articulation of BCE, and it's why, again, I admonish lawyers. Good lawyers should be advising their clients on where the law is going, how courts think about these things, and not saying you have to do this or you have to do that, but saying you should be aware that courts may take a more expansive view of your purpose, of your responsibilities, and you should be thinking about those things and making decisions. So in my mind, it's that interaction between courts and public and private actors that is pivotal. Should regulators be imposing rules? It's very hard for a regulator to frame a rule that says act reasonably. What regulators do is impose transparency requirements, which create incentives to act reasonably. And regulators say, here are our requirements, and we expect you to comply with the substance, not with the form. And those are two very effective instruments for raising the bar in terms of conduct.
Let's move on now to private remedies, meaning remedies available against private actors. Can you elaborate on some of the private remedies that are available?
Sure. This is sort of, in my mind, the most exciting part because private remedies and a sense of corporate purpose are moving in tandem. So it's not necessarily the courts sort of leading the corporate sector, or they're both going in tandem. The corporate sector is in some ways leading the courts. So think about directors' duties, or limited liability, or any of the sort of cornerstones of corporate law. Well, the corporate law hasn't changed for 100 years. But if you ask directors about what their duties are, they will tell you that their duties have changed. And the courts have articulated. So, for example, over the last 20 years, part of directors' duties is a duty to monitor, which has led to very robust risk management systems within corporations. A duty to treat stakeholders fairly. A duty to act ethically. These are all duties that have been articulated by the courts, but more importantly have been articulated by corporate leadership. The same thing is true of investment fiduciaries, and I raise it because we have moved to a world where the demographics of share ownership have in effect reconcentrated. We have a small number of very large passive investors who own everything. BlackRock, State Street, Vanguard. And for any major public company, those large passive investors own 20 to 30% of the company today. And that number is increasing. The ultimate beneficiaries, the investors in many of those funds, are either locked in because it's their retirement income savings or whatever, or they are effectively locked in because they are saving for long-term objectives. Most of us save for retirement income security, to fund our children's education, to have money for a rainy day if something goes wrong. Those are all long-term objectives. So the fiduciary should be thinking in the same way. And the most obvious example would be a trustee of a pension fund, a defined benefit pension fund, where the duty of loyalty has been interpreted to include a duty of impartiality. That is, as a trustee of that fund, I have a duty to be even-handed between current beneficiaries and future beneficiaries, including beneficiaries who haven't been born yet. Well, if I have that duty of impartiality, by definition, I have to be thinking about systemic risk because I'm investing for the long term. I don't know how I satisfy my duty if I can't answer the question, in my investment decisions, have I thought about the impact of climate risk? The answer may be I've thought about it, and whatever it is I've decided. But if I haven't thought about it, I'm not sure I've met my duty. So increasingly, just as with corporate director duties, the investment fiduciaries are the other side of the coin, and increasingly courts are imposing on them, in effect, a duty to consider and mitigate systemic risks. You then have private nuisance, which is essentially the same doctrine as public nuisance. That is, remedies are available when one can prove a substantial and unreasonable interference with the private use and enjoyment of land. But over time, the concept of land is expanding to a broader range of resources. Increasingly, the courts are imposing liability on insurers and on lenders, saying they had a duty in lending money or insuring risks to consider, potentially disclose harms that might be caused to third parties. So third parties are increasingly asserting causes beyond the corporation to banks, insurance companies. There is a claim that is being invoked called civil conspiracy, which is when you can prove a concerted action to accomplish some kind of unlawful objective which results in damage. So if multiple players within an industry, and then there are human rights claims, same as on the public side, which have been asserted against all sorts of companies, particularly in the resource sector.
Now, one of the private remedies that you have written about relates to disclosure obligations and the recommendations of the Financial Stability Board's Task Force for Climate-Related Financial Disclosure that you referenced earlier. Can you talk about the importance of transparency and meaningful disclosure? We've already touched on it to some extent, from a supervisory and regulatory perspective as it relates to climate.
Well, it's a great example of how standards evolve over time. So, and the core concept in securities law is materiality when it comes to disclosure. And 20 years ago, actually 30 years ago now, there was a petition brought to the SEC to require climate-related disclosure. The SEC opposed the petition. It was litigated. And what's interesting about it for me, and that was about the vintage that I was a securities regulator, so I knew all those actors. What's interesting to me is that, the then chair, the then head of enforcement, all of them today are active in advocating for increased transparency around systemic risks. IOSCO just put out a statement on environmental, social, and governance disclosure. Most regulators, including the SEC and the Canadian Securities Administrators, have put out guidance on materiality with respect to climate-related risks. And I think where we're probably heading to in the not-too-distant future will be some form of sustainability discussion and analysis, much as we now have management's discussion and analysis, and we have compensation discussion and analysis, not in any standardized format, because the metrics kind of haven't evolved to that stage, but an affirmative obligation on the part of issuers to discuss sustainability issues. That's where I suspect we're going to head in the next little while. In the meanwhile, I was a founding director of something called the Sustainability Accounting Standards Board, which now has a comprehensive set of standards. There are 2 or 3 other standard setters. So over time, those standards will merge, and we will achieve the kind of comparability that users are looking for in non-financial disclosure.
In closing, Ed, you've talked about the role of regulators and supervisors in addressing systemic risk as it relates to climate. Can you provide us with a description of some of the unique challenges and opportunities for regulators and supervisors in this space?
I think the art for regulators is not getting out ahead. So markets should lead on this, and as I've said, markets have led in terms of developing metrics for disclosure, whether it's a task force or SASB, integrated reporting. On the other hand, regulators shouldn't lag too far. Their job is to sort of nudge. So, they shouldn't be mandating prematurely, but they should be pushing things along. And on that, I'd give the regulator community sort of a C+ or a B- on that. There's probably a role for them to be a little more active than they have been so far.
Ed, you just alluded to the role of regulators and supervisors and the marks that you would give them with respect to the roles and responsibilities that they've taken to date. How could we move the dial from a C+ or a B- to a B+ or an A- in the future?
5 years from now, everything we're talking about is going to be taken for granted. Why? Just because of the shift in demographics. Our children are going to think about these issues very differently than we do, because for them, the option of punting it into the future won't exist. They are going to feel the impacts, and they are going to be aware on a daily basis of the fact that there's not a lot of time left to deal with them. So everyone will be thinking longer term and more systemically, because buildings are going to be a little bit underwater. We're going to, the evidence of systemic risks and the impacts are going to be with us, not sort of a theoretical possibility. Regulators, ideally politicians, should be thinking longer term. And if they are, they should be saying, okay, how can we accelerate that thought process? And whether it's doing like Mark is doing, using his bully pulpit to put ideas into currency, or whether it's being more aggressive in mandating disclosure, not the nature of disclosure, but mandating the requirement that companies or investment professionals talk about how they think about sustainability issues, what they do about sustainability issues. All of that kind of elevates the issues in public consciousness, which in turn I think will accelerate the process of thinking about purpose and how we address systemic issues in society today.
Thank you, Ed. It was great chatting with you. We could have certainly gone on for much longer, but unfortunately we have a limited amount of time. Thank you very much.
My pleasure. Thank you.